Hello and welcome to the second episode of TLJT Talks. Today we have with us Mr. Abhishek Naharia. Abhishek is currently an advocate at Rajasthan High Court. Abhishek has done his law from Rajiv Gandhi National University of Law and he has led Law and Tech Times of RG Annual in the capacity of Chief Editor. So welcome Abhishek.
Thank you so much, Aryavan, for having me here. It's my pleasure.
So the topic of our discussion today is admissibility of electronic evidence. Since childhood, we have been told this thing. If we go to our parents or someone that this happened to us or this guy said this thing to us, everyone asks for like what proof do you have? What is the evidence you have? So I think it's a very interesting topic that we are going to talk upon. And just for the sake of our listeners, I'd like you to throw some light on what do you mean by evidence? How will you define it?
Sure. So, if we go by the definition of the Black's Law Dictionary, then evidence is something that tends to prove or disprove the existence of an alleged fact. Now, understanding this in layman's terms, if we go to the court and if we say that there is an existence of a fact, there is a fact which has occurred. If we claim this in the court of law, the court of law will ask for evidence. So basically, evidence is something which substantiates the facts that you are proving or you want to prove in front of the court. And the law in India, which talks about evidence, is the Indian Evidence Act 1872. And it was first written by Sir James Stephen, the committee that he made. And after that, in 1872 is when it was enacted. And subsequently, through many major amendments, such as the one in 2013 and 2018, there have been amendments. And also through the IT Act, there have been some amendments. So, yes.
Right. So a long time has passed since 1872, and as you said, there have been many acts post that, many amendments post that, and everything has digitalized ever since. Like after the inception of computer and internet and mobile phones and this electronic media and all. So, if you could just shed some light on the definition of electronic evidence or how our listeners can understand what electronic evidence is.
Surely. So, as you rightly said, that it's been many years since 1872 that we have grown, and since the advent of the technology, there have been many technological advancements, and now a very major question that comes before the court of law while deciding about the evidence is on the topic of electronic evidence. So nowadays, when summons or anything related to law is being accepted and sent through modes like emails and WhatsApp forwards and WhatsApp messages, of course. So in this age where everything is being done in electronic form, and especially you see in the COVID times when everything was done in the electronic form, even the hearings also were done. So a major question arises as to what is electronic evidence. So for the meaning of electronic evidence, I would like to take you to the explanation of Section 79A of the Information Technology Act, which says that electronic form of evidence means any information of probative value that is either stored or transmitted in electronic form and includes computer evidence, digital audio, digital video, cell phones, digital fax machines. This is not an exhaustive definition, and through the judicial pronouncements and landmark cases, the definition of electronic evidence has expanded, and subsequently in the further part of the conversation, I'll take you through the landmark judgments. But for the meantime, electronic evidence just means any evidence, including the computer evidence, digital audio, video, images, recordings, WhatsApp messages, the social media, everything that comes under this. And the list, of course, is not exhaustive. It will add upon as we go ahead with time.
Right. So as you rightly said that we shall discuss about these few WhatsApp chats and all that to discuss later in this talk. But for now, I'd like to ask that is there any difference between electronic evidence and electronic record? Like how a common man, how a layman could understand what an electronic record is?
Surely there is. For the purpose of understanding the difference between electronic evidence and evidence electronic record, I would like to take you to section 2 subclause T of the Information Technology Act, which defines the term electronic record as data, record or data generated, image or sound stored, received or sent in an electronic form or microfilm or computer generated microfiche. So if I have to simplify this definition of electronic record, as has been stated in section 2 subclause T of the IT Act 2000, electronic record basically means anything which has been stored as an electronic evidence in a computer or a similar device. So supposedly, if in my phone I have an image, so supposedly the other day there was a theft committed, and in the CCTV of my house, if that theft was recorded, then the recording of the theft and the recording of the video that I have in my CCTV, that's an electronic record. Similarly, if I confess anything when I'm talking to you on WhatsApp, that is an image, and that would also be considered an electronic record. Similarly, other things like email, WhatsApp, Facebook, the records that I have to prove in front of the court of law, everything related to that comes under the ambit of electronic record. Another difference, another small difference that is between electronic evidences and electronic record is that the definition of electronic record is taken into consideration majorly while we talk about the admissibility of electronic evidence under the Indian Evidence Act. And when we talk about section 79A, that is not read directly with the 65A and 65B of the Indian Evidence Act. So this is another small difference. That electronic record is given more prevalence when we have to delve upon the admissibility.
Right. So you talked about preference. So this brings me to my next question. Like, what is your say on primary and secondary source of evidence as far as this concept of electronic evidence is concerned?
Sure. So basically, as I already told, that the Indian Evidence Act, Section 3, defines evidence, and it says that evidence can be either oral or documentary. So in layman's terms, oral evidence means anything which is spoken. So if supposedly in the court of law, I give an evidence and I exclaim before the honorable magistrate or the judge sitting there that, for example, I say to the judge that XYZ happened the other day. So if I'm speaking that will be oral evidence. And supposedly if I am being called by the court of law and I give the court of law a document, that will be considered as a documentary evidence. So basically this is the major difference. An oral evidence is something which is spoken. Documentary evidence is given in a documentary form. Now, moving further, there are categories in the documentary evidence. So in documentary evidence, we have the primary and the secondary evidence. So basically, primary evidence means the production of the original electronic record or the document. So if supposedly I have will and the case relates to a will, so the original will that I have, or if there are property papers, so the original property papers about which the claim is being made in the court of law, that will be considered the original ones as the primary evidence, right? And if supposedly there are certified copies, there are photocopies, right? And there are other electronic form of copies in the CD, in the hard drive, in the pen drive, saved in the laptop, in the phone, or anywhere else also. That will be considered as a secondary. So anything that is original is primary, and original or like original in the hard copy when you talk about the paper copy, the bills and all. And if it's a WhatsApp forward, etc., anything which comes from the phone itself or the laptop itself, for that matter, the device itself, the computer device itself, that is a primary thing. And anything which is being taken as a certified copy, as a printout, or is being stored in a computer-like device, that's a secondary thing. So it's called a secondary evidence.
Right. So anything that comes via something is a secondary evidence, is what you said, right?
Correct.
Okay. So you talked about the types of evidences that exist there. So this brings to my next question, that is what according to you are the different types of electronic records?
Right. So basically, the answer to this is very simple and very easy to comprehend. So as per the IT Act, it defines electronic records, and basically it covers a wide range of formats in which data can be produced. So it comprises of, if we start from the DVDs, CDs, which used to be in the 90s and the 2000s, then pen drives, telephonic recordings, then hard drives came, and we had emails. Then nowadays we have WhatsApp recordings, then coming over to the pictures, the video recordings, sound recordings. Again, the list is not exhaustive, and everything that I said comes under the ambit of electronic records, and there may be more things to it.
Right. So I have a simple question here. Like you talked about primary evidence and secondary evidence that exists. So do you think that secondary evidence can anyway be morphed, or its genuinity can be questioned in the court of law?
Absolutely. So basically what happens is in the court of law, when you are asked to produce a document that is in the form of the evidence. So under section 3 of the Evidence Act, you've been explained as to what is evidence, right? And now that I've already told you that electronic record comes in under the ambit of section 3 of the Indian Evidence Act. So any electronic record would be a documentary evidence, right? Now the question arises is the categorization that I already told, that documentary evidence can be primary as well as secondary, right? Now the question comes, is there a need to prove the authenticity of the document? Like you just said, just asked as to if there can be any changes made in the electronic evidence. So the answer is pretty clear that yes, there can be changes made, and there are separate tests for that in the electronic industry. We have experts, and they give their opinions. And basically, in the language of the Indian Evidence Act, if we say, then a certificate is required under Section 65B of the Indian Evidence Act to prove the authenticity of the relevant electronic evidence. So suppose if we both are talking in a WhatsApp chat today, and tomorrow if there's a claim, a fact that I'm wanting to prove in the court of law, and if I submit the screenshots or the printout of the WhatsApp chat before the court of law, then the court of law would not consider that as admissible as a primary or a secondary evidence, but it would want me to produce a certificate saying that the thing that I'm producing, the electronic evidence that I'm producing, is original, and that the court should consider it. So of course, morphing or changing can be done in an electronic evidence, but if you prove a certificate, if that is validated by the certificate, then of course the court will consider it admissible, subject to the facts of the case, of course.
Right. So you have to prove the authentication of the evidence that you are submitting. So is there some authority that authenticates the evidence that we submit? Is there some person, some authority, or some body that gives us the certificate?
So basically, there have been 4 landmark judgments, which I'll discuss eventually in the discussion, which talk about as to how is the certificate proven? Is the certificate very necessary? Can the evidence, electronic evidence, be not taken without having the certificate? So basically, telling you the gist or the crux of all the landmark judgments, the latest one being of 2020, I would like to say that there is no specific authority which is responsible for granting the certificate, but then, and also there is no specific format for the certificate which you have to submit to the court of law. So it can even be in the form of an affidavit, or it can even be in the form of a typed thing, which if you are a lawyer, you can type it on your head note or on an A4 page and formally addressing to the court of law. And of course, then that thing can be given to the court of law. And there's no specific judgment on the same. But then the law is evolving, and let's be hopeful if in the near future there's any specific guidelines laid down as to how a certificate should be, how it should be written, drafted, and how it should be submitted to the court. But as of now, the advocates or the people who appear before the court, the counsels, do it at their own peril as per the norm of the office that they're working in.
Right. So we have talked much about the law. So I'd like to take discussion further by asking you about what is your say on best evidence rule and section 65B of Indian Evidence Act.
Right. So as we all know that the best evidence about the contents of a document is the document itself. That is the primary evidence, as I've already told. And it is the production of the document, which also includes electronic records, that is required by Section 91 of the Indian Evidence Act in proof of its content. So basically, primary documents, primary evidence is always preferred over secondary documents as per the best evidence rule, right? Now, in a sense, the rule that is given in the section 91 can be said to be an exclusive rule, as it excludes the admission of oral evidence for proving the contents of the document, except in the cases where secondary evidence is allowed to be led. Now, section 65B is an exception to the best evidence rule. Now, what's happening here is, I'll just try to explain this in a layman's term. What's happening here is, as per the best evidence rule, you always have to produce the primary document, right? But as per section 65B, even if 65B in a manner, so it creates a legal fiction wherein it's a kind of a secondary document. So suppose we're talking on WhatsApp, and tomorrow if I give the printout, so that anyhow won't be original. No, I cannot produce the phone in the court of law and can say that, my lord, please see the phone. Of course, I'll take a printout and all. And if I substantiate that with the certificate under 65B, then it will of course be admissible as per the discretion of the court, obviously. So what I mean to say here is, as per the best evidence rule, secondary evidence isn't considered to be appropriate or over primary evidence. But now you see the intention of the legislature was very clear in 2000 when it drafted 65B of the Evidence Act. And now that they have drafted it in such a beautiful manner, it has removed all the ambiguities in the minds of the readers and advocates and honorable judges. And now, according to 65B, even if there's a secondary source of evidence, if it is substantiated with the certificate, according to the legal fiction, that will be considered as a primary evidence. So yes.
Right. So rightly pointed out, and you talked about the kinds of primary evidences that we have or secondary evidences that we have, the things that can be submitted before the court. You talked about the recordings, the call records, the WhatsApp messages, and all these things. So it brings me to my next question. Like, can you please specify on the admissibility of few of them, starting with video and tape recordings?
Surely. So as we've already discussed that there are a number of varieties of electronic records. As you've asked me upon the admissibility of the video and tape recordings, I'd like to mention a point here as to how evidence is produced in the court of law and how it is admissible and how is it proved. So basically, if I go to a court of law and state a fact, the court will ask me to produce an evidence, right? Now, I'll produce the evidence before the court of law, and now the court of law will see whether the evidence that I have produced is admissible or not, right? So admissibility of a document or of evidence comes after the relevancy, but before the proving of the contents of the document. So I would request the viewers to not confuse admissibility with relevancy or proving the contents of the document, because when evidence is admissible before the court of law does not deem it to be correct or right as per the facts of the case, but admissibility just means that the court of law will now look into the evidence that is produced. So if supposedly a WhatsApp chat is deemed to be admissible by a court of law, it means clearly that the court of law will now look into the WhatsApp chat. And it doesn't mean that the court of law accepted that the evidence is appropriate, and it will give decisions on the basis of that, right? So having said that, I'll move on to the specific question on video and tape recordings, right? So I'd quickly like to point out two landmark cases in the Indian arena by the Honorable Supreme Court. One is before the IT Act came in 2000, and one is after the IT Act. So before we had the IT Act, it is a 1971 Supreme Court case. So in Ziauddin Burhanuddin Bukhari versus Brij Mohan Ramdas Mehra and others, AR 95 Supreme Court 1788. The Supreme Court observed that the tape recorded speeches are a document as defined under Section 3 of the Indian Evidence Act, and it stands on no different footing than photographs, and they are admissible in evidence on satisfying the certain condition. So it's clearly stated that they'll be termed as a document under Section 3. Having said that, I'll move on to 2006 case. The Supreme Court in Jagjit Singh versus State of Haryana, 2006-11 SCC 1. It's a case relating to the Speaker of the Legislative Assembly of the State of Haryana, who was disqualified as a member for defection. So while hearing the matter, the Supreme Court considered the digital evidence in the form of interview transcripts from the Zee News TV channel, the Aaj Tak TV channel, and Haryana News channel. The court determined in this case that the electronic evidence placed on record was admissible and upheld the reliance placed by the speaker on the recorded interview, while reaching the conclusion that the voices recorded on the CV were same as those of the persons who were taking action. So the Supreme Court held in this case that it is admissible. So we can clearly see that even before the IT Act, the position of admissibility was clear. There was a little bit of ambiguity due to some decisions, but after the 2000 Act, things are much better and more clear and precise. So yes, they are admissible.
Right. So besides all the things that you said, I personally like when you drew a difference between admissibility and acceptance of evidence. I think this is something that we need to understand, that there's a difference between the two. And I'd like to quote one case in the state of Bihar versus Sri Radhakrishna. The Supreme Court observed that admissibility of an evidence is one thing and its probative value is another thing. So yeah, moving on to our next question. You spoke well about video and tape recording. So, but nowadays all the documents are being stored on computers or hard drives. So I'd like to ask you about what is your viewpoint on admissibility of hard disks in the court of law?
Right, as rightly pointed out by you, that hard disks are an essential feature of the storing of the electronic records nowadays, keeping into consideration that they have a very high storage capacity. So taking into account the size of the videos, especially apart from the images and documents, it becomes very easy for one to store things in the hard drive rather than stuff your computer or the laptop or the phone for that matter. So keeping in mind the relevance of the hard disk, I have a Delhi High Court case with me to substantiate my argument when I say that the contents of the hard disk are very much admissible in the court of law, right? So the Delhi High Court, in the case of Dharamveer versus Central Bureau of Investigation, it's a 2008 case, observed that while there can be no doubt that a hard disk is an electronic device used for storing information, once a blank hard disk is written upon, it is subject to a change, and to that extent, it becomes an electronic record. Even if the hard disk is restored to its original position of a blank hard disk by erasing what was recorded on it, it would still retain information which indicates that some text or file in any form was recorded on it and at one time and subsequently removed. But now see, the catch is here. So further, the court said, by use of software programs, it is possible to find out the precise time when such changes occurred in the hard disk. To that extent, even a 8 blank hard disk, which has once been used in any manner for any purpose, will contain some information and will therefore be electronic record. So the Honorable Delhi High Court in this case very clearly said that even if the contents of the hard disk are erased, right, then also it will be taken to be electronic record and be admissible in the court of law, just because of the reason that with the technological advancements that we have come through, the contents of the document can be retrieved from the hard disk, even if the documents are removed now and it's a blank hard disk. So you see the level of technological advancement that we have done, that even if the contents are not there in the current times, even if they have been erased, then also through some softwares, through the guidance and help of experts, we can retrieve the information. And as and when it is retrieved, it can be produced. And as per the discretion of the Honorable Court, it can be admissible. So yes.
Right. So rightly said about hard disk. So there's one more burning topic these days of call recordings. Like we we very frequently, not daily, very frequently we come across call records of politicians or big businessmen or these celebrities asking about things or telling things that should otherwise not come in public. So what is your say on that? Because these days we are seeing these things increasing at a very fast pace, and when it comes to question, when someone asks that person whose record is out, they just clearly deny it, that no, it's not me, it's opposition who might have released this tape just to defame me or present a bad image of me. So what is your say on the admissibility of call records in the court of law and its genuineness?
Right, as rightly pointed out by you, that recently in the case of Arnab Goswami, and more importantly in the Sushant Singh Rajput case, wherein Riya Chakravarti was under a media trial rather than a court trial, of course. But having said that, I'd like to say that call records are a very essential feature, not only today, but since a long time, because in India, it's been a long time since we have had phones, and we know it that if one person records the call of another, and if it's an official call or for any other purpose also, and if that is produced before the court of law, it's very prima facie clear that can be morphed or the voice can be changed. And also the question arises before the honorable court when such call records are placed, that whether the voice is same as that of the person who is claiming the fact to be true and producing the evidence concerned. So I have a case of Delhi High Court, although there have been a number of Supreme Court judgments, but since this case is one of its kind, and the first ones which talk about the admissibility of call records, in Rakesh Kumar and others versus State, it's a 2009 Delhi High Court case. The court, while appreciating the reliance placed by the prosecution upon the call records, observed that computer-generated electronic records is evidence admissible at a trial if proved in the manner specified by Section 65 of the Evidence Act. So the court in this case very clearly said that if the call records are not morphed, if they can be given with the certificate of originality or of genuineness under Section 65 of the Evidence Act, then there is no doubt, and then they can be very easily be admissible under 65B of the Evidence Act. So yes, they are admissible.
Right. So rightly pointed out by you. I think we should be more careful from next time onwards. Some friend of ours tell us that, we are recording this call just for the information purpose or whatever you're saying it. I just want to keep a record of it. So we should, from next time onwards be more attentive and towards whatever it is. And yeah. So you talked about Section 65P of Indian Evidence Act pretty frequently during whole discussion, and just for the sake of our listeners, I'd like to reiterate that it's something, it says that whatever is recorded in computer or any electronic storage, it shall be treated as a document of evidence, and it can be produced in court of law without any further proof. So here my question to you is, or my request to you is, kindly throw some emphasis on this and substantiate it with the help of some Supreme Court judgments, if you.
Surely. So now if we talk about the admissibility of electronic record under 65B, although there have been a number of judgments, but I've handpicked 4 of them, which have been the most landmark ones and which have stated the law, or which have overruled the earlier position of law, so to say. So the first judgment is very famous one, landmark one, State and City of Delhi versus Navjot Sandhu, 2005. It's a 2005 2 benches judgment of the Honorable Supreme Court, where it was held that the certificate under Section 65B subclause 4 is not mandatory, and document can still be admissible under Section 63 and 65 as secondary evidence. So for the viewers, I'd like to say that 63 and 65 of the Evidence Act deals with the secondary evidence, right? So basically, secondary evidence, as they are not primary and they come second, they are not direct evidence. So this violates the best evidence rule, right? But here, the court said that even a secondary evidence can be admissible under Section 63 and 65, and the requirement of the certificate is not mandatory. So this is a landmark case, as this did not happen with such a bench prior after the IT Act came in 2000. So basically, in this case, to conclude, the court said that certificate is not mandatory, and you can prove the electronic record as a secondary evidence, right? Now, overruling this case, we have the 2014 Supreme Court judgment of Anwar PV versus PK Bashir. It's a 3 judges bench case, and therefore only it could overrule the earlier case. And it held that by overruling the state versus Navjot Sandhu, that section 65A and 65B are special provisions, and special provisions always overrule the general provisions. Thus, the certificate is mandatory, and there are total 6 requirements as per section 65B in the certificate, which should be proved to make the electronic record evidence as admissible. So it's clearly pointed out by the court that state versus Navjot Sandhu is a bad law, and that certificate is compulsorily required if the computer device is yours, or even if the computer device is not yours. That is to say, if it is in the hands of the third person, right? So this was a overruling which came as a surprise to the litigants. And now moving on to the next case, that is a 2018 case, Shafi Mohammed versus State of UP. Out of the 4 cases that I'll cite, 2 have already, and I'm on the 3rd one, and another one I'll come on. Out of these 4 cases, I'd like to say that the Shafi Mohammed versus State of UP 2018 case is the best case, as it cleared the position of law as to the admissibility of electronic evidence in a very precise and clear manner and an easy manner, right? So without further ado, I'd like to say that in this case, the court held that it has to be seen as to from which computer the output has been taken, right? For explaining this, I'd like to draw your attention to a very easy example. So if supposedly you and me get into a fight in front of my house today, and supposedly you are living in front of my house, and the next house is yours in front of me, and you have an CCTV evidence in your home CCTV camera, and you have evidence in that. So if you are the culprit here, and if supposedly I file a case against you, and if you are the accused, and if the matter goes to the court, now how would or why would you give a document against yourself, and why would you say to the court that Lordship, I'm giving a certificate of me being the culprit or of me being the accused? So this is very illogical to say. So in these cases where the computer device is not yours, like in the example I gave, the computer device or the CCTV evidence is in your home and not in my home. So in such cases where it is not possible to bring on electronic evidence from my computer, then the court held in the Shafi Mohammed case, then the electronic evidence will be taken to be admissible even without the certificate, right? But if the computer is mine, and if I had the CCTV in my house, then of course I'll have to prove the genuineness of the electronic record. And then of course you can say that the certificate is necessary. So basically, Shafi Mohammed case divided the whole scenario into parts. First, wherein the computer device is in my control, it's mine. There, the certificate is necessary. That's very logical and legal also. Second, in the second case, it's not mine, the computer device, and it's in the hands of a third party, right? And in that case, the court said that the certificate, requirement of certificate is not mandatory, right? So the court will consider the evidence as admissible even without the certificate. I hope that I was little clear with this point. And now moving on to the last case, it's Arjun Pandit Rao versus Kailash Kushan Rao. It's a 2020 judgment, 3 judges bench of the Supreme Court. Before moving on to quickly to the judgment, I'd like to say that this judgment has again created a ruckus or a chaos, so to say, with all due respect to the Honorable Supreme Court judges in the field of the admissibility of electronic evidence, because it has in a manner overruled the Shafiq Mohammed judgment, which was very clear, very logical, and very sound as far as legal reasoning is concerned with regards to this topic. So after the Arjun Pandit Rao judgment of 2020, we are back at point 1 or point 0, so to say, Now we are back at 2005 State versus Navjot Sandhu, where there was again the doubt whether the certificate is required or not. So now coming on to what the court said that the certificate is mandatory in all cases whatsoever. The discretion should not be given to the party. So as a critique or as or in terms of explaining it to the layman, I'd like to say here that this judgment has again created a confusion in the mind by saying that certificate is necessary in all cases, where I've already explained the loophole in the earlier case that if the computer device is not in my hands and is of a third party, then if the third party supposedly is a culprit or an accused in the case, why would it produce the genuineness of the document against him or her? So this loophole again remains to be in the hands of the honorable judges, and I hope so that in the coming time, very soon, the discretion is given again to the parties as to the production of the documents, as was held in the Shafi Mohammed case. Yeah, so this is it. These were the four judgments, and I hope I've made things clear.
So that right, Abhishek, you rightly pointed out about all these four judgments. And one thing that struck my mind is when you said that we two of us had a fight and it got recorded on my camera. So this just gave rise to a question in my mind that public recording, it's not a crime. Like if a camera is positioned on a road just for the safety of house or for public, so that's not a crime. But if I get into your house and record something, that's invasion of your privacy, and that's, I think, private recording is a crime. So what do you think about sting operations? People don't take consent before recording those things, because these call records and all, people first take consent that we are going to record your call, we are going to record your tape, audio, video, or whatever it is. But for these sting operations, I think this electronic evidence that we talked about, tape and audio evidence and all these things, they are not recorded by consent. So what is your say on this sting operation thing? Should it be admissible in the court of law?
Right. So coming on to the question of sting operations and their admissibility as evidence in the court of law, I'd like to make it very clear that sting operations are of two kinds, right? One is the positive sting operation, which is done in public good to expose any wrongdoing in the society. And second is the negative sting operation, which is nowadays become a trend by the media channels and the press people, with all due respect, to expose the so-called big news channels, right? So now you see in the negative sting operations, as a matter of fact, the court would not take those evidences with caution or with ease, because the ultimate purpose was exposing or was immoral or not right as far the societal terms and public good is concerned. So this, having said this, coming to the positive part of the sting operation, which is being done in public interest, I'd like to say that the court does not directly takes the evidence to be admissible prima facie, but then there have been landmark judgments where the court has said that yes, the evidence in a positive sting operation could be taken into consideration while determining a relevant fact or a fact and issue in the given case. And there have also been contrary judgments to this. So to conclude, I'd like to say that there are no specific guidelines being laid down by the Honorable Supreme Court, or for that matter, any High Court, as to the admissibility of sting operation. But we should keep in mind one thing, that as far as the Evidence Act is concerned, it doesn't matter to the court of law or to the honorable judges sitting there that how is the evidence procured. As far as the evidence is admissible or is relevant to the fact which you are trying to prove, that is the relevant fact or the fact issue, right? So the procurement of the evidence is hardly a question before the court of law, as far as the evidence that you're proving is relevant in the current case. So having said that, I'd like to say that the court takes the evidence through the sting operation, the evidence which is brought from the sting operation, it takes it into consideration with due caution, and only if there are corroborative evidences and evidences that support the fact that you are proving, only then the court considers it totally admissible. And when eventually if the reader proves the point, the contents of the document, so to say, the court can give this judgment in the favor, or vice versa, whatever the case may be. So the position is not clear, but then the court can take it into consideration as admissible with proper caution and precaution. So that is all that I'd like to say here.
Right. Thanks a lot, Abhishek, for throwing some light on this, because I think this is a topic that would have come to everyone's mind after listening to whatever discussion we had, that what on these listing operations. So you very rightly pointed out about these things, and yeah, it should be admissible in public interest. So yeah, I think this discussion of ours will prove fruitful to our listeners, and we may keep engaging in future also. Thank you, thanks a lot for making time for us. Thanks.
Sure. Thank you so much for having me on board today. And
Pleasure,
I'm grateful and pleased. Thank you.
pleasure. Thanks.